But the main issue, which was whether the investigation was conducted fairly and properly, was never made a point of consideration.
It's a matter of evidence. You can cross-examine the IO. You will get advantage of that glaring error. If an IO has not properly investigated the case, you will get advantage. आप अपना एक्यूटल क्यों खत्म कराना चाहते हो? उस लेक्यूना को क्यों complete कराना चाहते
We
हो?
are only
खाली पे सजा के दिया गया एक्विटल का केस।
तो फिर आपकी सिर्फ मंशा यह है कि किसी तरीके से इस केस में विलंब कारित किया जाए।
मतलब आप-
पहले प्रोविजन तो पढ़ने आपने बोला कि आप जो कहाँ से वकालत सीख के आए हैं भाई?
sorry, my lords.
Once you say I want to draw attention of this court to section 465, then you are first required to show us that what is the provision and how it helps you. Then the judgment will come.
My lord, this is a criminal revision, my lords.
Huh.
My lord, the applicants filed a 156(3) application before the learned trial court.
Which
On a-
application?
156(3), my lords,
Huh.
on account of fair and improper investigation carried out by the prosecuting agency in this case, my lords. My lords, in this case, an FIR was registered against the applicant number 1, and all his family members 2, 3, and 4 were also impleaded as accused in the FIR, my lords. Now, my lords, in this case, there was a set of 80 questions which were asked by the prosecuting agency from these applicants under section 91 of the CRPC, my lord, because those were essential questions forming, and they wanted to investigate upon those questions. And that is why these questions were asked, my lord. Now, my lords, that questions were asked on 17/12/2019, my lords. My lords, we filed, those questions dealt with issues pertaining to 20 years old also. So, my lords, we filed 5 interim replies to these set of questions on 26/12/2019. My lords, I am having a synopsis also. My lords, may kindly have this from this.
एक मिनट रुक जाइएगा।
Yes, my lord.
ट्रायल रुका हुआ है।
My lord, the charges are also not being framed as of now, my lords, in this case.
आपका प्रयास तो यही है।
My lords, in fact, if your lordships may kindly,
आपका कंडक्ट दिखाई दे रहा है ना, इस तरीके से चीजों को डिले करने का प्रयास किया जा रहा है।
my lords, in
पहले
this case,
91 से पहले सुन लिया जाए, 156 बाद में किया जाए।
my lords, in this case, there, because my lord, there is a list of 80 questions. That was the primary issue involved in this case, my lords. A set of questions were asked, and my lord, those answers were also given to us, but those answers were not considered. And in the charge sheet, they say they have never filed an answer. My lord, there's a series of events which has happened in this case, which we have mentioned in our synopsis, my lords. In fact, my lords, in this case, the IO was also changed, but the third IO has sent the case for prosecution sanction. Whereas after that, the fourth IO was appointed, he gave us notice and he has taken our evidence also. But before that only he has sent the, in fact, the IO was also not competent to send, my lords, in this case. I'll describe, my lords.
देखिए 156(3) में ये कवर होगा क्या फॉल्टी इन्वेस्टिगेशन? थोड़ा दिखाइएगा और साकरी बसों में भी दिखाइएगा कहाँ है प्रावधान। जी कहाँ क्या स्कोप है 156(3) का और साकरी बसों का क्या रेशो है, थोड़ा बताइएगा।
Yes, my lord. Well, it's Sakari Vasu judgment.
हाँ
Lordship, this judgment says that 156(3) provides for a check by the magistrate on the police performing the duties under chapter 12 of the CRPC, my lords. In cases where magistrate finds that the police has not done its duty of investigating the case at all or has not done it satisfactorily, he can issue direction to the police to do the investigation properly and can monitor the same.
जी
Section 156(3) is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation. And it includes the power to order registration of an FIR and for ordering proper investigation if the matter is satisfied, if the magistrate is satisfied that the proper investigation has not been done or is not being done by the police. Full stop. Section 156(3) CRPC, though briefly worded, is very wide and it will include all such incidental powers as are necessary for ensuring a proper investigation.
जी
My lords, in this case, we filed the 156(3) application before the learned trial court. In fact, my lords, the trial court judgment may kindly be seen for a moment.
जी
My lords, on page number 62
जी
of the trial court judgment, we have prayed a relief nat number 2. The number 2, which was the most important relief, without prejudice to the prayer clause 1, the Lokayukt organization shall be directed to conduct fair and proper investigation in the matter. My lords. But my lord, the learned trial court has framed the points for determination in the impugned judgment on page number 89.
yes
And my lords, on page number 89, there are 4 issues which have been framed by the learned trial court. But the main issue, which was whether the investigation was conducted fairly and properly, was never made a point of consideration.
it's a matter of evidence. You can cross-examine the IO.
Malaj, because in this case, a very glaring error has crept in, which will be clear by.
You will get advantage of that glaring error. If an IO has not properly investigated the case, you will get advantage. आप अपना एक्यूटल क्यों खत्म कराना चाहते हो? उस लेक्यूना को क्यों
मतलब
treat कराना चाहते
we
हो?
are only.
खाली पे सजा के दिया गया इक्विटल का केस।
तो फिर आपकी सिर्फ मंशा यह है कि किसी तरीके से इस केस में विलंब कारित किया जाए।
Malaj, our intention is that, Malaj, I'm relying upon judgment of Babu Bhai versus State of
दीजिए,
Gujarat.
बाबू भाई भी दे दीजिए।
Yes, Malaj, it is uploaded on the reference.
हाँ, बताइए,
Or to see.
हाँ, बाबू भाई वर्सेस स्टेट ऑफ गुजरात। यस,
Yes, Malaj. Malaj, this case itself, Malaj, it says that a valid investigation, a vitiated investigation would lead to a vitiated charge sheet, Malaj. Malaj, in this case, we are not seeking an.
if the charge sheet is vitiated, the accused should be happy।
Malaj, the submission, Malaj, my submission is that,
पढ़े ना,
Malaj.
उसका रेशो तो पढ़े, बाबू भाई का जरा समझे तो बाबू भाई क्या कह रहे हैं और किस कॉन्टेक्स्ट में है ये जजमेंट।
नहीं, आपने एप्लीकेशन लगा के यू हैव मेड योर पॉइंट, जब गवाही हो उसका एक्सप्लेनेशन दीजिए, अगर वो एक्सप्लेनेशन नहीं देंगे तो एक्विटल हो जाएगा आपका।
Malaj, in this case, if the charge sheet itself is vitiated on single point, Malaj, the one point which is required to be considered is this, Malaj. They have asked for a list of 80 questions. That means that questions are important. We are ready with the answers to the 80 questions which were asked under section 91. When we have gone to the answers, then they are not accepting an answer. And in the charge sheet, they are stating that you have never submitted an answer. We have also filed a complaint against the Sanjay Shukla, who was the investigating officer. My lords, may kindly see in this case, there was an investigation first carried out. A closure report was being filed. But that has come in the affidavit of the Lokayukta organization only. Then the IO gets changed. Second time, another IO comes, another closure report gets filed in this case. That is also there in the affidavit of the.
Filing of closure report.
They have prepared the closure, my lords.
ठीक है, filing, preparation of closure report is one thing, and acceptance by the concerned judge is another. Closure will be complete when it is accepted by the concerned special judge. ठीक है, merely filing of the closure report by the IO is not a sufficient circumstance to help you. We are aware of this fact. Two, if there are any lacunas, then they will give you benefit in the long run when IO comes to the witness box.
My lords, in this case, if the matter is redirected, and our only prayer is that they may consider our submission and they may refile the charge sheet, my lords.
Achha.
We are not seeking that. We are not seeking.
Charge sheet as directed by you.
My lords, I'm not saying, my lord, as directed by, but at least they're the answers which they have sought from us. And because, my lord, those answers are playing very crucial role because they're increasing my expenses and not increasing my income. Because this is the case of disproportionate assets, my lord.
ठीक है ना?
My lord,
disproportionate assets में तो वैसे भी prosecution को prove करना difficult रहता है।
my lords, may just kindly have a series of events which we have mentioned in our synopsis.
बाबू खान पर आइए ना।
Yes, my lord, Babu
Sir,
Bhai.
division का scope बहुत limited है।
My lords, Babu
We are
Bhai.
not hearing an appeal.
Malaj, Babu Bhai says that where the court comes to the conclusion, Mala, I'm reading the placetum only. Mala, it will be clear from the placetum itself. It starts from held, my lords. On page number 3. Not only fair trial, but fair investigation is also part of constitutional rights guaranteed under Article 20 and Article 21 of the Constitution of India. Therefore, investigation must be fair, transparent, and judicious as it is the minimum requirement of rule of law. The investigating agency cannot be permitted to conduct an investigation in a tainted and biased manner. The investigation into a criminal offense must be free from objectionable features or infirmities which may legitimately lead to a grievance on the part of the accused that investigation was unfair and carried out with an ulterior motive. It is also the duty of the investigating officer to conduct the investigation, avoiding any kind of mischief and harassment to any of the accused. Full stop. The investigating officer should be fair and conscious so as to rule out any possibility of fabrication of evidence, and his impartial conduct must dispel any suspicion as it is genuineness. The investigating officer is not merely up to bolster up the prosecution case with such evidence as may enable the court to record a conviction, but to bring out the real unravished truth. When the court comes to the conclusion that there are serious irregularities in the investigation that had taken place, the court may direct a further investigation under 173(8) CRPC, even transferring the investigation to an independent authority rather than directing a reinvestigation. Scheme of investigation, particularly 173(8), provides for further investigation and not reinvestigation. Therefore, if the court comes to the conclusion that investigation has done in a manner with an object of helping a party, the court may direct for further investigation and ordinarily not for.
Therefore, if the court comes to the conclusion that the investigation has been done in a manner with an object of helping a party, the court may direct for further investigation and ordinarily not for reinvestigation. फिर उसके आगे पढ़िएगा, the expression ordinarily means. पढ़िए. The expression ordinarily
ma'am.
means normally.
It means,
The expression ordinarily means.
it's lost. Therefore, if the court ordinarily, the expression ordinarily means mean normally, and it is used when there can be exception. It means in the large majority of cases, but not invariably. Ordinarily excludes extraordinary or special circumstance. Therefore, unless an extraordinary case of gross abuse of power is made out by those in charge of the investigation, the court should be quite loath to interfere with the investigation, a field of activity reserved for the police and executive. In exceptional circumstances, the court, in order to prevent the miscarriage of criminal justice, if considers necessary, may direct for investigation de novo, wherein the case presents exceptional circumstances. Where non-interference of the court would ultimately result in failure of justice, the court must interfere. In such a situation, it may be in the interest of justice that independent agency chosen by the High Court makes a fresh investigation. Thus, in case of malified exercise of power by a police officer, the court may interfere. Whereas in this case, there is exactly, all these issues are very clearly raised in our application, my lords.
Where is your application?
Yes, my lords. Section 156(3) application is annexed at
A3.
P3.
P3, my lords.
यहाँ A3 लिखा है इसमें.
Yes, my lord. A3, मतलब page number 105 onwards, my lord.
अभी वहाँ पे चार्ज के लिए चल रहा है ना?
हाँ.
My lords, the matter.
देखिए, आपकी दो प्रेयर थी, एक में तो उन्होंने बोल दिया कि आप एप्रोप्रिएट स्टेज पे करें. जब वो चार्ज लगाएंगे, प्रोसिक्यूटर विल पे फॉर फ्रेमिंग ऑफ चार्जेस अंडर सच एंड सच सेक्शन एंड यू विल सीक डिस्चार्ज. उस स्टेज पे जज कहते हैं, ट्रायल कोर्ट जज कहते हैं, इन देयर इज सफिशिएंट प्राइमा फेसी एविडेंस फॉर फ्रेमिंग चार्ज अंडर दिस सेक्शन. हो सकता है अगर उन्होंने एविडेंस फॉल्टी इन्वेस्टिगेशन से एविडेंस कलेक्ट नहीं हुई, दे विल डिस्चार्ज यू और फर्दर इन्वेस्टिगेशन करेंगे. आप एक्चुअली प्रीमेच्योर स्टेज पे आ
Well, in fact, this application was filed immediately after the charge sheet was filed, and there were 4 applications filed, my lords, in this case. 2 were filed after the filing of the charge sheet, and 2 were filed before filing of the charge sheet, my lords. And my lords, if lordships will kindly see the application, the allegations which we have left, it was, my lords, the issue of fair and proper investigation was never investigated, because that was the main point to be considered by the learned trial court, which has been omitted in this judgment.
मेन ट्रायल के पहले फेयर इन्वेस्टिगेशन हुआ है कि नहीं, इसका एक मिनी ट्रायल कभी नहीं होता क्रिमिनल केस.
Fellows, in this,
साहब एक ट्रायल इस बात का होगा कि इन्वेस्टिगेशन फेयर हुआ है कि नहीं, वो उसी का पार्ट एंड पार्सल है. डोंट आस्क फॉर ए मिनी ट्रायल.
Malaj, we are not asking, Malaj, in this case, there is actually, Malaj, we just see the list of events which has happened in this case, Malaj. Malaj, this is an extraordinary case.
ये नहीं कहना कि आपके आर्गुमेंट गलत है. एप्रोप्रिएट स्टेज के पहले ही उठाए, बोले वो स्टेज ही नहीं आने
Malaj,
देते.
we have come before the court immediately when the charge sheet was in our hands, and when, even before the charge sheet was,
Actions will be kept pending and will be
but
decided
that has been
at the
decided.
charge of. फिर आप चार्ज के खिलाफ आइए ना. देखिए, अगर इफ दे फ्रेम चार्जेस कम केस, आप ये प्रोसिक्यूशन का ये कहना था, डिफेंस का हमने ये कहना था, हमने ये आपत्ति.
नहीं, आपका आवेदन भी देख लीजिए 156(3) में. आपका कहना है अंकित द्विवेदी, मोना द्विवेदी, उनके इंडिपेंडेंट प्रोफेशन है, इंडिपेंडेंट बिजनेस है, उनकी अलग इनकम है जो कि टाइम टू टाइम डिस्क्लोज की गई है. ये सब मैटर ऑफ एविडेंस है. ये
Malaj, the main point is 80 questions point which we are pressing before the
This
Honorable
is
High
not
Court.
the first application, my lord, which they are moving. Earlier also
My lord,
had made an application making allegations against the PP. And that case was also, my lord, decided by this honorable. I have uploaded the
Mal-
order on reference, my lord. Similar
कौन सा
content.
ऑर्डर है वो?
Ravikant Devedi versus State, my lord.
हाँ.
NTRC number 5028/2022. In that case also, my lord, they had filed an application under section 156(3) making allegations against the PP. That application was also dismissed and they approached this honorable court. This case was also dismissed.
Malaj, that was on a different footing altogether, my lords. Here we have only come with respect to the 80 questions asked under section 91 of the CRPC, the answers to which were ready.
Ready means
They asked us questions, we
Right.
gave them the answers, but those answers not considered. On the contrary, they are saying that you have never filed answer. And we filed a complaint against the third investigating officer Sanjay Shukla to the SP, my lords. The SP changed the IO, and after that IO, then fresh IO was appointed, Mr. Naveen Avasthi. He gave us notice to come and give our evidence. We went to give our evidence, and our evidence was taken and our documents were given. And later on, it was mentioned that 15 days के बाद आइए, आपके बाकी लोगों के evidence तब लेंगे. But when we went there, they said आपका केस तो जिस दिन हमने आपको बुलाया था, उससे पहले ही हमने prosecution sanction के लिए भेज दिया गया है. That is the, and there are 2 complaints on our affidavit against the Sanjay Shukla IO. SP ने उसको change भी करा है, my lords.
He has not been made
आपने
part.
अपना जवाब दिया, जवाब की आपने प्राप्ति ली कि नहीं? आपने एक पावती ली हो?
हमारे हैं पावती.
बस बात खत्म है. इससे ज्यादा देखिए, डिफेंस हैज नॉट टू क्रिमिनल ट्रायल में, इवन इन डिस्प्रोपोर्शनेट केस, यू डोंट हैव टू प्रूव योर डिफेंस एज द प्रोसिक्यूशन हैज टू पे. आपको जो बात कहनी थी कि हमारे परिवार के लोगों की आमदनी और खर्चे हिसाब में नहीं लिए, दे आर इंडिपेंडेंट यूनिट, बस आपने अपनी बात कह दी. लेकिन
because the questions which were asked to us, but those questions, every question has a value attached to it, value in terms of monetary terms, my lords. And
चलिए, और बताइए, ये तो 2 आर्गुमेंट्स हो गए आपके, और कोई आर्गुमेंट है?
मनुष्य पर सबसे
I would not be supplementary. It's very ably, my lord, he's put forth. The only, my lord, the seminal question that comes up from my lords is, at the appropriate stage when the trial goes on, my lord, my submission is these questions would have been considered. There would be no requirement of anything. It would have covered everything. Why would I be subjected to the rigmarole of trial? Everything is explained along with this receipts, entries, documents, everything we've given. And he's very intelligently realized that if that is taken into account, his case goes. That's why they're not sought to be taken.
इसीलिए आपको लिबर्टी दी है ना, पैरा नंबर 110 में.
जी,
उन्होंने आपकी बात में ऐसा नहीं है कि आउटराइटली उनको
नहीं सर, मैं बिल्कुल
बस एप्रोप्रिएट स्टेज की बात हो रही है.
अब वो सर appropriate stage, remaining portion of my life, my lord, will be an appropriate stage. That's the unfortunate part.
देखिए, अभी तक जो भी विलंब हुआ है, शुद्धम शुद्ध आप उसके लिए जिम्मेदार है. नोबडी इज रेस्पॉन्सिबल. मुझे चलाने हमने 4 आईओ चेंज करा लिए. वकील साहब ने बोला हमने 4 तो आईओ.
why would I change the IO, man?
अभी बोले यार कि हमने ये
वो तो closure report लेकर आए. Those IOs are in my favor. The report was in my favor.
उन्होंने बंद किया सर. जब हमारे फेवर में देखी 2 रिपोर्ट्स उन्होंने चेंज कर दिया IOs.
तो हम ही करेंगे ना.
And my lord, as per instructions received, my lord, why there is a delay in the trial? Because other accused persons are not accepting the copy of the charge sheet. One person has accepted, others are not accepting. There is no trial is not proceeding.
अब हम आपको एडवाइस करने के लिए तो नहीं बैठे हैं यहाँ पर कि क्या करना चाहिए आपको. That is left to the wisdom of the trial court. But as far as this criminal revision is concerned, we don't see any material to show indulgence.
My lords, in fact, my lords, I would like to draw your lordship's attention to section 465 of CRPC.
Yes, 465 CRPC.
And
पढ़िए 465.
सर इससे रिलेटेड जजमेंट है सर. प्रदीप,
पहले प्रोविजन तो पढ़ने. आपने बोला कि आप जो कहाँ से वकालत सीख के आए हैं भाई?
सॉरी my lords.
Once you say I want to draw attention of this court to section 465, then you are first required to show us that what is the provision and how it helps you. Then the judgment will come.
Yes, my lords. So section 465 subclause 2, it reads that, sir,
पढ़िएगा.
in determining whether an error, omission or irregularity in any proceeding under this code or any error, irregularity in any section for the prosecution has occasioned a failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings. Now, my lords, on the
पहले
basis,
1 तो पढ़ लीजिए.
yes, my lord.
1 के
Subject to the provisions herein before contained, no finding, sentence or order passed by a court of competent jurisdiction shall be reserved or altered, reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaint, summons, warrant, proclamation, order, judgment or other proceedings before or during trial, or in any inquiry or other proceeding under this code, or any error or irregularity in any sanction for the prosecution, unless in the opinion of the court, a failure of justice has in fact been occasioned thereby.
जी.
Lalo, my lords, relying on the basis of this section 140, it's 465, my lords. a judgment of Pradeep Vodiyar has been passed,
Pradeep,
which has also been uploaded, my lords.
Pradeep Vodiyar, yes. Unless a failure of justice is proved.
Because we have to come at the appropriate stage, which, as
you.
early as possible, my lords. In this case, we have come at the earliest possible, immediately when the cognizance was taken, my lords.
You filed applications under section 156(3) prior to taking of the cognizance.
2 were filed before, my lord, 2 were filed after.
आपका कंडक्ट तो रिट लार्ज है ना, और जो ये कह रहे हैं वकील साहब कि आप चार्जशीट की कॉपी नहीं ले रहे, आपके को एक्यूज आप सभी के लिए आए हैं ना.
Yes, my lord. My lords, in fact, there is a order of the trial court which clearly says that charge sheet आपको देखना है कि सारे proper pages, because there is a huge charge sheet. And my lords, there are certain defects.
आपको डेट फिक्स कर देते हैं, उस दिन जाके चार्जशीट इंस्पेक्ट कर लीजिए और ले लीजिए.
In fact, there are multiple judgments of Honorable Supreme Court at the stage of framing of charge. Defense has not to be seen. By and large, generally that is the rule.
My lord,
So
अगर किसी
that's why
समय-
it makes it all the more imperative कि वो material आ जाए, defense तो देखेंगे नहीं हमारे.
लेकिन यहाँ पे इन्होंने दिया है ना आपको at appropriate stage. अब what appropriate stage वो trial court.
Earliest.
यहाँ पे इन्होंने खुद ही कहा है कि भाई आप चार्ज फ्रेमिंग के उस स्टेज पे वो करें.
my lords, one more important thing is that, my lords, that once the 4th IO has been appointed by the Lokaयुक्त itself, my lords, the 3rd IO is personally interested in the case, and he is the one who is filing the charge sheet and sending the case for prosecution sanction.
क्या उसको आपने पार्टी बनाया है क्या?
He has not been made party.
उसको पार्टी बनाया है तो बताइए, फिर आगे की बात
My
करते
lords, we have mentioned this
नहीं,
clear
mention
fact.
से नहीं होता ना वकील साहब. If you are alleging any malafide against the 3rd IU, then the first principle says that he should have been implemented as a party. So that argument goes in absence of he being made a party. चलिए, क्या करना है? मेरिट पर चाहिए कि विड्रॉ करना है?
We would like to have it decided on merit.
हाँ ठीक है, सीधी ऑर्डर. लेकिन साथ में डायरेक्शन भी देंगे इनका लिख के कि आप अपीयर होंगे मंडे को और चार्जशीट की कॉपी लेंगे. ठीक है, थैंक यू.
सर मैं आई स्पीक समथिंग.
नहीं, बीच में नहीं.
207 में अपन ने एप्लीकेशन दी हुई है कि हमारे डॉक्यूमेंट दे दें, उन्होंने तो डॉक्यूमेंट नहीं दिए. दैट इज व्हाई वी हैव नॉट रिसीव्ड चार्ज शीट.
My lords, in fact, this.
सॉरी, उनको बोलिए ये पीछे बैठे हैं, ये बीच में इंटरफेयर ना करें. He should have given you these instructions before.
Only.
Sorry, yes, will not entertain anything.
But in